Can your landlord make you get rid of your emotional support animal? The first thing you should know is that your lease might say no pets, but when it comes to emotional support animals, the law makes an exception. Hi, I'm Nikki. I'm an attorney with over 10 years experience practicing real estate law in New York City. And on this channel, I break down everyday legal issues to help you understand your rights. Quick disclaimer, this video is for general informational purposes only, not legal advice. Laws vary by state and city, and your personal situation matters. If you're facing this issue or a similar issue, consult an attorney or local housing agency. Today, we're covering emotional support animals and what to do if your landlord tells you to get rid of one, which is one of the most common questions I get as a tenant lawyer. So first, what exactly is an emotional support animal? An emotional support animal, or ESA, is not the same as a service animal. A service animal is trained to perform specific tasks, like a seeing eye dog guiding a person with vision loss. An ESA doesn't need special training. Its role is to do work, perform tasks, provide assistance, or provide emotional support for individuals with disabilities that affect major life activities. However, it's important to note that fair housing laws apply to both service and support animals, so for our discussion here, we'll use the two terms interchangeably. A support animal can be a dog, a cat, or in some cases another type of animal. However, generally it must be legal. This means you can't claim that your Bengal tiger is an ESA. The key is that you need the animal to help you manage your condition or alleviate the symptoms or limitations of your disability. Now, what qualifies as a disability? Under the Federal Fair Housing Act, a disability is a physical or mental impairment that substantially limits one or more major life activities. So that can include depression, anxiety, PTSD, or other conditions diagnosed by a licensed professional. To qualify for an ESA under the Fair Housing Act, you don't need to provide documentation of your disability if it's readily apparent or readily obvious. For example, if you are blind and have a seeing eye dog. If your disability is not readily apparent, for example, you suffer from depression, your landlord can ask for reliable documentation of your disability. A certificate from an online ESA service usually won't cut it. You need to provide something from a licensed healthcare professional, for example, a letter from your therapist or social worker stating that they treat you for the medical condition, which affects a major life activity, and that you need the animal to help you manage that condition or to alleviate your symptoms. The healthcare professional must actually know you and treat you. Importantly, your landlord cannot demand detailed medical records so long as you've provided that basic, reliable documentation. A simple letter is usually enough. Now, let's talk about your rights. Under the Federal Fair Housing Act, landlords must make reasonable accommodations for tenants with disabilities. That includes allowing emotional support animals, even if there's a no pets policy. What your landlord can't do is charge extra pet rent or deposits for an ESA, refuse the animal just because of breed or size unless it poses a direct threat, or harass or retaliate against you for requesting the accommodation. If your landlord still refuses, you can file a complaint with HUD, which is the Department of Housing and Urban Development. HUD investigates housing discrimination cases and can take action against landlords who break the law. Also remember, states often have their own human rights or fair housing commissions. Sometimes states provide even stronger protections than federal law. You may want to file with these local commissions first or in addition to HUD. Keep in mind, having an emotional support animal is a legal right, but you're also responsible for the animal's behavior. If your dog is aggressive or your cat damages the property, the landlord may have grounds to act. Important to note, if you have a support animal or intend on getting a support animal, you should make a written request to your landlord and notify them about your disability and the need for the animal. You can make this request at any time, even after your landlord files eviction papers. So, if your landlord tells you to get rid of your emotional support animal, don't panic. Know your rights, get your paperwork in order, and if needed, reach out to HUD or your state agency for help. If this was helpful, hit like, subscribe, and drop a comment with your questions.